this is a high risk game happening in this era, especially.
Absolutely, you're right. Absolutely.
Sir, we are live on YouTube, and Sharina, can you share the link on the chat box also so people can share?
Okay, sir.
Femi Ansar Sahab. He said, Mr. Femi Ansara.
Yes, Mr. Yes, Dr. Kaiser. How are you doing?
Good to see you, mashallah.
Good to see you.
Yeah, very happy.
Good to see you.
Mr. Femi is very much well connected with our community, Dr. Saab, in Dubai, and then we are now asking him to come and have, sessions with us in Abu Dhabi also.
Please, they are always welcome. I used to meet the ambassador frequently before, and he always invite me in Dubai because they have more companies in Dubai than Abu Dhabi.
More activities actually. People do come to Dubai and then they go to Abu Dhabi. So most of the events are all in Dubai.
Always welcome. We'll be very happy to have you here also. And I'm very happy to see Saeed Saab also. For BizLance Legal, I've never heard BizLance Legal before.
We'll come and see you later on.
Saeed Saab and Saif Saab, we have already shared the link on the chat board that this program is live on YouTube, and just in 2 minutes we are going to start this one.
Okay.
So if you want to share with your any colleagues, anybody, you can share that the program is now live.
Okay.
No, I think it will be very educative and in input. I'll share you. We are Chartered Accountant Office here in Allied Group, Abu Dhabi, apart from Pakistan Business Professional Council. So we have one client from somewhere from Germany, and they say that you show me your data privacy and protection. How
absolutely.
They are showing me about the German standards and other standards, how you protect your data, how you will keep information of my client who is not accessing. So we are from Allied Group, so we already have protocols. So we passed all the protocols to them, so they said that's fine. So without data protection, and especially health data, is so important.
Yeah, you're right.
I'm sure sometimes, Safrullah Sahab, I'll learn what happened 2 days ago for ADGM. Might be some good points.
Sure. We'll meet and we'll discuss, inshallah.
Sure.
Okay, now shall we start now?
Yes, please.
Okay. Okay. We are pleased to welcome you all at the webinar on personal data protection, Know Your Obligation, jointly organized by Ahmed Al Akbari Chartered Accountants and Balance Legal Consultant. Am I pronouncing correct? Balance?
Vigilance.
Vigilance Legal Consultant, supported by Malaysian Business Council UAE and Pakistan Business and Professional Council UAE. So as you're aware that there are some questions which will be answered during this webinars by our distinguished speakers, that does this law affect your companies or business? Do you have employees? Do you have customers? Do you have clients? Do you collect or use personal data or individuals in UAE? If these are the above yes, then this law affects your businesses. And this law is the law is in US Federal Decree number 45 of 2021. US Federal Protection Laws refer as Law 45 of 2021. This is programmed, as I already told, is supported by Pakistan Business and Professional Council and Malaysian Business Council. With us, the distinguished guests are there. I will first, request Dr. Kaisar Anis, who is the president of Pakistan Business and Professional Council, to have some words from him about this webinar. To you, Doctor.
Good afternoon, everyone. Assalamu alaikum. I must thank Asif Saab, Sayyid Asif Zaman Saab from sorry, Asif, from Ahmed Al Jabri, Chartered Accountant, and also from Vigilance, Mr. Saeed Hassan Khan Sahab. And also I welcome Mr. Safiullah Khan and Mr. Femi Ansara from Chairman, Malaysian Business Council UAE. Data protection is the most important thing thing in this era of 2023, especially United Arab Emirates, which is showing progress and nearly 200 nationalities living there. We live in a data-driven world. Sharing data can make life easier, more convenient, and connected with all us. How it happened, any company here or any organization who was functioning in United Arab Emirates supposed to take care of data. And in this respect, as Mr. Asif mentioned, the law is there, came in 2021 last year. All organizations have a responsibility to adhere to this, to protect the data they are holding for themselves, their client, and for any other entity internationally, not only in UAE. You have a responsibility for that. If you do not expose or do not control, you have to have a proper officer for data protection who can take care day to day, because every day you can see how many calls, how many scams are coming to each organization. Your iCloud server, your own server should have been protected and should have proper firewall. This is the area where international world, especially United Arab Emirates, has been focused by international people. Unfortunately, they think that our things are not been protected. They keep on trying, and our organization, apart from Pakistan Business Professional Council, for example, representing Abu Dhabi, and the Elliott Group, Elliott Hadishai Chartered Accountant, Elliott Management Consulting, we are coming across every time challenges. Apart from that, what challenges is happening in the past time is happening. It was very easy for us to operate, and I do take the finance part, that you issue the checks and the checks been deposited and checks been withdrawn. Very easy, very comfortable, and you have everything. Now, the transfer of funds is by instruction. When you transfer the fund, you have to be very careful and cautious, and you have to have a controller on that account. You can imagine in a day, billions of funds have been transferred. I will give an example that one should take care when they transfer the fund, especially the IBAN number. You have to be careful with your IBAN number, and you have to be careful with your title of account. Supposing I give an example, and this is for learning for everyone, this is practical things happening which we face, and how I got it protected is that you give an instruction to your client to transfer money. Somebody hacked your transfer. He changed your name only. So the supplier, when they send to you, your name is there, but the IBAN number is changed. So what happened? The payment went to Elliott, but it fell down to other IBAN number. And you have not received that money. And that money is gone. So I contacted some of the cyber consultant that how to protect this. And that's what idea I'm going to give to this all audience which is listening, that he suggested do by telex. By transfer by telex is safe. Recently, I transferred a big money from Canada to London. So they instructed only on telex, nothing else. And we did it that way. So with that, I would like to listen all the experience which Mr. Other speaker we have, and I hand over to them. And my best wishes, hopefully at the end of the day, all the audience will have a lot of knowledge in respect to data protection. Thank you very much.
Thank you very much, Dr. Kessler. And then I will now invite Mr. Femi as our good friend, and he is the chairman of Malaysian Business Council, really a very well-known businessman and very excellent technical person I have met. To you, Femi.
Thank you very much, Mr. Asif. Hope everybody is well. Dr. Kaiser, Mr. Saifullah, Zaid. Thank you very much. Can you hear me first?
Yeah, we can hear you. Yeah.
Okay, all right. Well, Assalamualaikum and good afternoon. I am basically today representing Malaysian Business Council. Thank you. I'm very happy to be here with all of you. And first, I want to say, of course, my thank you and special appreciation to Mr. Asif and Ahmad Al-Akbari, Chartered Accountant, for the invitation to MBC to support this event. Well, Mr. Asif is my good friend, and he's also a member of Malaysian Business Council. And my special appreciation. So I want to say something with Mr. Asif. He's even though he's not a Malaysian, he's like a Malaysian already, supporting our event and promoting basically the relationship between Pakistan businesses and also Malaysian businesses. So personally, I would like to thank again Mr. Asif for his support to Malaysian Business Council and his assistance in many other things. And I would like also to thank Dr. Kaiser. I think we have also participated in your events, quite a few, and the relationship that your association have with not only with the MBC but also with our government was really, really good. And thank you for always connecting with us and share with us your programs and activities, and definitely refreshing of such active council who have a lot of members and supporters. So today on the topic of this data protection is very interesting topic. And as of course, as Dr. Kasir mentioned before, it's very, very important and critical, important, especially when we are managing our business, especially now where the information are flowing freely. Are we protected? Our clients protected? Our business protected? So these are the questions. So how can we protect ourselves? So I'm not going to say a lot of things because need the expert to handle this. I just want to say thank you for everyone who actually joined us for this event, and I hope that this kind of event will be organized more, and we hope to get more members from both sides to come and join us in the future. So thank you again, and hopefully we have a good session at the end of the day. Thank you very much. Thank you, Mr. Asif. Over to you.
Thank you very much, Femi, and hopefully that our collaboration over here and in Pakistan and Malaysia will go further ahead with the efforts and support from Dr. Kessler and others like Mr. Saeed and Mr. Saif. And now I want to welcome our speakers for today. We have two speakers, Saeed and Saif. They both are the partners for business legal consultancy and consultancy, and they have a company of I think law firm in Pakistan also. And Mr. Saeed is very well known in business community, over very active person, and over 20 years of experience in practicing direct and indirect taxes, federal and provincial, which encompasses all the practice tiers of advisory, execution, litigation, including tax planning, returns preparation, risk assessment, tax audit, transitionary advisory, and other things like that. And then he has very personal interest in emerging laws, to have gain understanding of the underlying concept and principle governing the global data protection laws, including general data protection regulations of IoT. Yeah, so many lots of things. If I take one time, so I will not be enough. So you, Mr. Saeed.
Thank you, Mr. Asif, for a good introduction. And also thank you for Dr. Kesser and Mr. Fehmi to give their introductory remarks. So I will start my presentation now. I'll share my screen. So before I start my presentation, I would like to briefly introduce what I'll be discussing today. So my presentation will cover the basic important concepts of the personal data protection and the rights and the obligations placed on the users of data or personal data. Saifullah will be discussing the rights of the data subjects, the important topic of cross-border transfer of personal data, and more importantly, what companies need to do in order to be compliant with this new regulation. So briefly to explain that in UAE, there are three set of different laws governing personal data protection. Firstly, there is Federal Decree Law number 45 of 2021 on personal data, which is a federal law which is applicable all across 7 emirates. Then the two of the free zone in UAE, they have their own personal data protection regulation, which are Abu Dhabi Global Market and the Dubai International Financial Center. They both have their own set of legal regulation and the framework which govern specifically for their own jurisdictions. Now I'll discuss briefly what is the purpose of these regulations. Basically, the purpose of this regulation is to provide a framework to facilitate the easy flow and exchange of information with the object to protect the rights of the data national persons. The basic purposes of the law is to make a regulation and to regulate the use of personal data of national persons by the companies. So there are three elements in this. There are three elements in this whole concept. The first comes national persons, which are called the data subject, like we all are. The main purpose of the law and the regulatory framework is to protect the interests and the legal rights of the national persons. The national persons are called data subjects in the law. Then there comes the companies or the user of personal data. Like the employers, the hotel industry, the telecommunication industry, the banks and the health industry, they all are using the personal data, and these are called controller. Slideshow. So I'm sorry, but now I think my slides are visible. Yeah, okay. So at the first pillar, I repeat it in brief. The law covers the natural persons who are termed as data subjects. The law places certain rights on the data subject just to protect their rights and to protect their data from misuse. Then there comes the controller and the processor. The controller and processor are the person and the companies who use the personal data of the natural persons. The law places certain obligations on those controllers and the processor. Then there comes on the third pillars, there come a regulator whose job is to regulate this whole mechanism. In UAE, the name of the regulator is TDRA, Telecommunication and Digital Government Regulatory Authority. Now, before moving forward, I'd like to discuss a few important concepts. To understand the whole process of data privacy, certain concepts are very important to understand. So I'll start from the personal data. What is personal data? The legal definition given in the relevant law is appearing on the screen, but on a very simple language, I would say personal data is something which directly or indirectly identify a natural person. Any information which helps identify a natural person is a personal data. Now, sensitive personal data is another term which is separately defined in the law. And sensitive personal data includes data about the natural person like criminal records, health data, and mental care data. Now the concept, two important concept which I mentioned when I say that the law places obligations on the user of personal data. So these are the companies or the who use the personal data of the natural persons. So one is the controller. Controller is a person who himself or itself decides the purpose and its utility to use the personal data. For example, an employer is a data controller when he decides to use the personal data for his employment purposes. A hotel administration, and airlines, a bank, a telecom company, when they use the data of their subscribers or their customers, it is a controller. So the law places certain obligations, which we'll discuss later on the controllers in order to protect the personal data of the natural person. Then there comes the concept of processor. Processor, in simple words, is a third-party service provider who processes the data on behalf of a controller. The processor person who does not itself decide about the collection and the purpose of processing the data, but it only acts on the instructions of a controller. Another important concept is the consent. The consent is the single most important legal parameter under which a data controller or data processor, for that matter, can use the personal data of a natural person. Without having a consent, a data controller or data processor cannot use personal data of the natural person. Please more discuss and highlight the importance of consent later on. The next important concept is of processing. What is processing? So processing, the legal definition is here, but to clarify it in a simple words, data processing is any action which involves right from the collection till the destruction of erasure of data. We store the data, we transfer the data, we process the data, we analyze the data, anything, any set of action which is done right from the collection till its ultimate erasure is processing. Now, the name of the law is Personal Data Protection Law in UAE. So the term personal data protection is itself defined in the law, which means to have a set of technical and organizational measures which are required to be taken by the companies. I repeat, the technical and organizational measures which are required to be taken by the controllers and the processor who use the data. And we'll discuss in detail what does it mean, the technical measures, and what are the organizational measures in order to protect the personal data. Before proceeding further, I just give a couple of examples to highlight which information is the personal data. For example, the first email address appearing in this very slide is info@company.com. This piece of information of this email is not identifying a natural person. So it's not a personal data. So the law is not applicable on this sort of information, whereas the email address given at number 2 and number 3, they are identifying a national person. So this is the subject matter of this law because this piece of information is directly identifying a natural person. So these two are the examples of personal data. Now I'll come to discuss the obligations of the data controllers and data processor. When we say the obligation, why we say it's obligation? Because the law or the legal framework requires the user of personal data to use the personal information or the personal data of natural person under certain set of regulations and under certain principles. So these principles are the obligations based on the data controllers. They have to fulfill this obligation. So we can say if any data controller, processor, or we can say any company is not able to follow this obligation, that means that the organization will be in non-compliance of the law. So to be compliant and to remain compliant, all the companies need to have fulfilled these obligations. The first and the foremost obligation is the principle of lawfulness, fairness, and transparency. What does it mean? It means that the data controller must act lawfully. Lawfulness means the data controller must have a legal and specified purpose of the processing. Without any purpose, he cannot, or the company cannot process the data. Fairness means, and the transparency means, the data controller must be open and fair and tell all the required information to the data subject that I am using your data for this purpose I am using, and after this much of time I will erase this data, and more importantly, if I'm required to share your data with third parties, what these third parties are to whom I'm going to share your data. Then there is a purpose limitation. It's very important obligation on the data controllers that if you need a data controller, for example, a company, if collects data of its employees for the employment purpose, it has a clear and specific purpose for the purpose of employment and offering employment. The same data cannot be processed for any other purpose. For example, continuing the example of the employment, if an employer takes the data of its employees for the purpose of employment, it cannot share this data for the insurance or the bank or the telecom providers to offer their products to their employees. So it is not the same purpose. So its purpose limitation is a very big obligation placed, and it must be fulfilled by the data controllers. And secondly, it's the third more important obligation is that personal data cannot be processed for any other purpose. The purpose for which I have taken the consent from a natural person, I am supposed to process the data only for that very purpose. The next important obligation based on the data controller is data minimization. That means that only that amount of data is to be kept and processed which is required for that purpose. This principle is called data minimization. The data controllers or the processors are not allowed to keep excessive data. They need only to have the minimum data required to fulfill their lawful purpose. Then they have the principle of accuracy comes, or the obligation of accuracy comes, which means that data must always be accurate, correct, and it should be up to date whenever required. Then there is storage limitation. As I mentioned that when the data controller is required to take a consent from the natural person who are data subjects, so when its purpose is fulfilled, thereafter data controller must not keep the data longer than when his purpose is finished. It is only allowed to keep the personal data till the purpose is not fulfilled. Once the purpose is fulfilled, the data is to be deleted permanently. One exception law gives if data is anonymized, that means the identity of the natural person is concealed, then the law allows the data controllers to keep the data further. Security, as I mentioned, that the whole law is about the protection of personal data. So the next obligation is security, to keep the personal data secure from unauthorized access or breach or misuse. This all comes within the security. Now, how the data controllers are to ensure to make the data secure. So as I mentioned that while I was discussing the definition of personal data protection, I mentioned that the law requires the security by two means. Firstly, the technical measures, and then the organizational measures. So what does the technical measures mean? Technical measures mean which data controls are to take in order to protect the personal data and the personal information, the security of the system, the security of their devices, their online security, the security of their places. So no one can intrude and extend the data. And then when we come to secure the personal data through organizational measures, it means that firstly, having an overall culture at all levels of the organization, be it be board level or the C level or executive level, every employee, there should be an organizational culture that this is the requirement, this is the legal requirement, and we need to build such processes and system at an organizational level to make sure that the personal data which an organization is being processing is kept safe and secure from external vulnerabilities. The examples of organizational measures may include carrying out a risk assessment to know which are the weak areas and where the organization or the companies for data need to work more hard to protect the data. Then nomination of focal person, who is the local focal person who is going to take the driving seat to run the organization about data privacy. Then there must be business continuity plan, just in case there happens a breach or unauthorized access or misuse of data, what need to be done. And more importantly, because the organization, which I say the data controllers or the data processor, must not wait to happen something wrong. They must have exercise or a mechanism to have a periodic checks to check their organizational measures and the technical measures, whether they're working good or not. A record-keeping obligation is also there on the data controllers. Actually, the law, when we discuss the transparency and fairness concept, so For transparency and the fairness concept, the data controller is required to keep all the records of the processing they do, including what they are processing, what kinds of data they are processing. Are they only processing the ordinary person data, or they are processing the sensitive person data? Who the person within their organization are authorized to access their data? For what reason they are authorized to access that data? What is the time restriction? What is the time frame after which the data will be deleted? And what is the mechanism to safely erase or make modification in the data, and the description of the technical and organizational measure, what organizational and technical measure are being taken by the organization to support, to protect the data, and the consent management, how you take the consent, what is the mechanism to take the consent, where you keep to the consent, and when an authority asks and come to you and you say, where is the consent, how you can reproduce the consent before the legal authorities. Now, I will more discuss now the consent, because I mentioned that consent is a single important element under which the law allows a data controller to process the personal data. So a consent must be valid. An invalid consent is not a legal basis to allow a data controller to use the data. So what is the essentials of a valid consent? Firstly and foremost, the controller should be able to prove that he has taken the consent. At times come from the regulator point of view, when the data subject goes to a litigation, so data controller must be able to demonstrate that I have taken a valid consent. Then the consent must be specific. It not be unambiguous, very clear and very concise. This shows that data subject has freely given his choice to use my data by the data controller. And another important thing is that the data controller must give an option and a very easy and clear way to withdraw the consent. The withdrawal of consent should be as easy as to excise or to giving the consent. Now, the document or the forum or the mode which is to be used by the data controllers to acquire the consent must have at least 3 to 4 important elements to contain within it. For example, the name of the organization, who is the data controller, then name of the third parties to whom data controller will be sharing my personal data, why my personal data is used, and what I will use, why I will use the personal data of natural person. These are the requirements to build in the consent document. Now I'll discuss how to obtain and record the and manage the consent. It is a basic principle of transparency and fairness that while I am taking the consent from the data subject to a natural person, I must be very fair, honest, and clear with the data subject. So my consent taking process must give an active option to the data subject that, okay, I'm taking your consent. Are you going to give me consent? Pre-tick box or the pre-tick box are not a valid consent. And if a data controller need to have different purposes for different data set, so it has to obtain different consent for each different purpose. It is to withdraw the consent should be as easy as to obtain the consent, and more importantly, to keep the record of the consent and to have a continuous review of the consent because of changing circumstances. I'll give a couple of examples just to explain the importance of consent. In this example, the vendor or the website owner has drafted or written the privacy notice in a misleading way, because it says, please do not send me the following types of communication with the pretext block on industry news. That means by default, if a data user do not take anything, then by implication, the website owner will be sending all this information. And secondly, a pre-tick box is against the concept of valid consent because it is making me forced to use this. It is not giving me a free and clear choice to exercise my choice. Another example is this. In this, when a website holder is using a cooking privacy notice, but it's not giving another option. It's only the continue. So the user of this website is forced to just to accept and continue. There must be, I agree, I disagree, or more importantly, please view our cookies for privacy. Had it been there, so this option would be a valid consent. But at the moment, it is not fulfill the essentials of a valid consent parameters. One of the obligations on the data controller is to notify a data breach. just the data breach is unauthorized access, which could lead to unauthorized access to personal data by external persons. So the law requires whenever there is a data breach, so the data controller is to notify the authority, DTRA, and the data subject that the breach has happened, and in which case, not all breaches are required to be reported, but there are 3 significant elements under which, if the breach affects that, then the data controller is to report this breach to the data subject and to the regulator. When the privacy of data subject is compromised, or the confidentiality of the data subject is compromised, or when the personal data is itself unsecured, remain unsecured, then a data controller is to notify the breach to the data subject or to the regulator. Now, the law also requires what you need to be reported in the data breach notification. So it must give a description of the data breach, what happened, and details of data protection officer. If any, I'll discuss who is data protection officer and why it is required to be appointed. And now importantly, what are the expected effects on the breach and what actions data controller has already taken to minimize or to mitigate the negative effects of the risk arising about the breach. Now I'll explain the data protection officer, the role of data protection officer. In certain circumstances, the data controllers are lawfully obligated to appoint a data protection officer. And in which cases the law requires the data protection officer to be appointed is that when a data controller is processing data which gives a high risk to the privacy of people, or they are processing a high or large amount of sensitive personal data, or when the processing involves profiling and automated processing. And to give an example, when we receive the automated emails targeting my previous purchases or my previous spending pattern, that this is automatic processing. Whenever a company or the controller or the organization is making automated processing, it needs to appoint a data protection officer. Now, what is the job of the data protection officer? Its main responsibility is to make compliance of the controller and processor with the legal framework. And it also has to inform the controller and processor of its legal obligations. And the data protection officer is to act as a contact point between the regulator and the organization itself. The role of data protection officer can be internal or external. Law doesn't place any restriction, and the role of data protection officer can be outsourced. Lastly, I will discuss about if some company or the controller for that matter fails to implement or to follow or comply with the legal requirements, then there are some penalties will be imposed. As I mentioned, that executive regulation has not been issued so far. So the executive regulation, when issued, they will define the limits of fines and the different offenses. But just to give an example, in this slide, I'll try to show that what are the level of penalties in similar legal frameworks in other jurisdictions. Like, for example, GDPR, under General Data Protection Regulation of the European Union, the penalty is 20 million euros or 4% of the global revenue, whichever is higher. For ADGM, the maximum penalty is $28 million. And for the DIFC, the maximum penalty is $500,000. That's in my presentation. Now over to
say thank you. One more important point. Can you tell the audience again the penalties, that how heavy the penalties are there, that if things goes wrong?
The penalties are heavy. Now the law is there, but the law has not defined the level of penalties. The executive regulation will be issued, which will define the level of penalty for what offense, for what non-compliance, which penalty will be there. But I just shown, for example, that for what penalties are there for under the GDPR law, under the DIFC law, and under the ADGM law.
Thank you.
That's in my presentation. Thank you very much.
It's so nice of you, and you have elaborated all the things. Now, our next speaker is an international trade, technology, policy lawyer, having more than 20 years of practical experience in the area of international trade policies and law advice. He carries expertise in WTO laws, include agreement of anti-dumping, agreement of subsidies, and countervailing years.
Asif, your voice is not correct. Your voice is not correct.
Hear me now? Hello.
It's okay.
Yeah, it's okay now.
No, again, something wrong in our voice. Always from beginning. Anyhow, go ahead.
Maybe, no problem. Sorry for that one. So I will request Mr. Saif. Mr. Saif. Can you unmute? Saif, can you unmute?
Yes,
Saif,
thank you very much. Yeah, can you see my slides, please?
no. Can you share that?
Share करना है direct.
इसको बड़ा करें, ये करें, ये स्क्रीन शेयर।
Yeah. Yeah, can you see my presentation? Is it okay now?
Yes.
Yeah, it's fine.
Okay, thank you very much. Thank you very much. Good evening now. I think it's more than 5, so good evening, everyone. Thank you very much for this opportunity. Saeed has explained some important legal elements of the data protection law, more on the obligation side of the data controller and the data processor. I'll talk about the rights of data subjects. Data subject, as he has already explained, data subject means we all are data subjects, natural persons, human beings. Then I'll talk about the cross-border transfer of personal data, which is a very, very sensitive and important issue being discussed in every forum, in every seminar or webinar being held in different jurisdictions. And then finally, I'll talk about the practical aspects that what needs to be done by a data controller and data processor right now as we speak today. So that will have some practical implications, actions to be taken by the companies who are processing the data. So first, the rights of data subject, as we all know that the main purpose of this law is protection of personal data of individuals. So this law actually provides extensive rights to the data subjects, the natural persons. One of such right is the right to access to information, which means that the data subject can ask the controller to share the categories of data which is being processed by the controller, the purpose of processing of the data, and with whom the data is being shared. So you have the right as an individual data subject to ask these questions from the data controller. Then the next one is the right to personal data portability, which means that you have the right to receive structured and a machine readable form the data so that you can transfer from one data controller to another. You don't need to give your thumb impression to each and every authority where you go. Once you have given your thumb impression to a particular authority, then you can ask that authority to transfer the same to the other data controller. Another right of the data subject is the right to rectification or erasure. If a data subject believes that his information, his personal data is incorrect with the data controller or the processor, he can ask to rectify the same. And even the data subject can ask the data controller to erase his data. For example, when you withdraw your consent, Saeed has talked a lot about consent management and how important it is the consent to take the consent of the data subject. So if a data subject wants to withdraw the consent, obviously after your withdrawal, you will ask the erasure of your data from the record of the data subject and the processors. The next is the right to restrict processing. There could be a scenario where the data controller or the processor are processing your information for non-agreed purposes. In that particular circumstances, you can restrict your processing of data by that particular controller or the processor. Right to stop processing. Another good example that being a data subject, you can ask the data controller to stop the processing if you are receiving automatic, that marketing emails, or if you believe that your data is being processed now outside of the legal framework, which does not have any legal purpose at all. You can ask the controller to stop the processing of your data. right to object to automated decision making. Now, automated decision making means that some decision has been taken for that data subject or the natural person based upon purely analytical data analytics without using of a human mind, without using of any human mind in the data decision making. For example, for a traffic violation, a criminal is given a high penalty just because of its previous criminal record, without involvement of human mind and without considering the fact that what actually the violation is. But just because there is an automated decision making, the previous record indicates that he is a criminal, so he was given a high ticket, which is not reasonable at all. Cross-border transfer of personal data, as I have already mentioned, I would like to mention that there was last Tuesday, just 2 days ago, there was a International Data Privacy Day at the ADGM, Abu Dhabi Global Market. Saeed and myself was also there. It was organized by the US Embassy in Abu Dhabi along with the Data Protection Office of the ADGM. And during that session, it was a very good session of around 4 hours. There was a lot of discussion about cross-border transfer of personal data because it's a huge issue. The data has to be transferred, personal data has to be transferred from one jurisdiction to another. It has to go out from the UAE, it has to come into the UAE. So there is a lot of discussion still going on about the harmonization of regulations and how you can harmonize regulations in one jurisdiction and the other, so that the transfer of personal data could be done easily. And this exactly what is mentioned in the law of the UAE, that you can transfer personal data from UAE to outside the UAE if the other country, state or territory has the same adequate level of protection for the processing of personal data. So this is really very, very important aspect, because if the other country, the jurisdiction, they do not have the law, they do not have the implementation of the law, then it is difficult, it is not allowed for you to transfer data to that jurisdiction. The next point is to state or territory with whom UAE has bilateral or multilateral agreements. Up till now, there are no such bilateral or multilateral agreements in place, but yes, what is expected that once the executive regulations are issued, for which we all are waiting, that executive regulation is likely to provide more guidance about the cross-border transfer of personal data, and then we might see some bilateral or maybe a multilateral agreements in the near future. The most practical aspect of my discussion is what needs to be done by a data controller or data processor. For example, the companies who collect the data, the companies who process the data, what they are required to do now. The first step is assessment of overall impact about the data landscape, which means that you need to figure out what kind of data you have about your employees, your customers, your end user. What category of data do you have, do you collect? Then establishing how data was obtained and whether it was fully informed consent was given. Again, at a very important point, Saeed has already emphasized on this consent management, taking of consent from the subject matter. So you need to establish a framework, you need to establish a process, rather, I would say, that whenever you get a consent, you should have a consent management program very well documented, so that if in case there is some litigation, in case there is an inquiry against you, you should show the regulator that you have taken the consent, which is fully informed. Creating a data processing register, which means that you need to maintain a register which shows that how data is collected and saved, where it is transferred, for which purpose the data is being used, and with whom you are sharing that data. And that also includes any third-party suppliers like the cloud service providers. So they also include in this data register. You'll be able to recognize and respond to requests from a data subject. So this is again a right given to the data subject, that if the data subject files a request to the data controller, for example, a request of erasure, and then the request of maybe access to the information. So you need to have that mechanism in place, the process in place, that whenever you get a request from the data subject, you need to respond to it quickly and accurately. So you need to have that mechanism with you. Ensuring capacity building of employees, very, very important. It is extremely important that your employees must know what actions are required from them in case there is a breach of data from your company, or in case there are some other vulnerabilities. The employees have to be very well aware about the responsibilities with respect to the obligations of the company. Be always transparent with the data subject. Again, I would say Saeed emphasized on this issue as well. You have to tell the data subject why you are collecting the information and for what purpose and with whom you are going to share the data. Again, I would say if the data is being shared with the third party like cloud service provider, it is the responsibility of the data controller and the processor to make sure that the cloud service provider has a proper mechanism in place to keep the personal data secured. It is your responsibility because you are sharing the information with the third party. The companies, they have to review their existing business processes, and what they have to do is to see what are the gaps, and you have to make your business processes in line with the new legal framework. There is no way out. You have to do it. The more earlier you do, I think the better you would be in the near future. Decide who is in charge of a data protection obligation and whether you have a legal duty to appoint a data protection officer. Again, it is very important. Saeed has already highlighted circumstances and the situation where you have to appoint data protection officer. So you need to analyze whether you are processing the sensitive personal data, extensive sensitive personal data. And if you are doing it, then obviously you need a DPO. You have to modify, review, and update your agreements. Even if you are, for example, if you are providing services online on the web portals, etc., then you need to, amend your web agreements. You need to amend your privacy policies, your cookie policies to make them in line with this new legal framework. You need to document all your policies and procedures so that they are in place. Everybody in the organization know what they have to do, what are their responsibilities, and how they're going to react in case there is any query from third party. You have to prepare a compliance checklist and its periodic review. Again, we know how the professionals, we do it quite regularly. Either it is a taxation, either it is a corporate compliance requirements. You have to have a proper compliance checklist with you for this regulation as well, for this law as well. And you need to get it reviewed periodically to make sure that there is no contravention of the law on your end, because the penalties are huge. Saeed has just shown you the benchmarks, but I tell you, the companies in Europe, they have faced penalties from 220 million to 400 and 450 million euros. The penalties are really, really very huge. Okay, so data mapping again is one of the very, very important aspects or steps, I would say, to be taken by the data controller and the data processor. And data mapping means taking stock of all the personal data that you collect, that you process, and you need to know that what do you do with that personal data and where that personal data goes in your company. And while figuring out this question, you need to first answer that what kind of data you are collecting. Either you are collecting emails, you are collecting the personal addresses, or some medical record, or some mobile number, or their photographs, and so what kind of type of data you are collecting, and how consent is obtained, whether it is fully and free consent from the data subject. What is the purpose of collecting data? You need to know, and you need to define it, and you need to document it, so that if there is a scenario that regulator has to come into your office for any kind of surveillance and supervision and enforcement, you should be ready to explain and show all the records properly. Whose data is being collected? It is important because the collector has to decide. The data collector has to decide. The data controller has to decide that what kind of information I have to receive and for what purpose. So the data collector has the duty to define whose data I need to know. Access control, very, very important, that you need not to give access on personal data to each and every person in your company. That should be controlled. Data transfer security is again very, very important. It comes under the big umbrella of cybersecurity, that you need to ensure that the transfer of data from one system to another, from one place to another, from one jurisdiction to another should be very, very safe. Timing of data collection again, what time is needed for the data collection, for how many months, for how many years you need that data, because you cannot keep it for excessive time. Where you have stored the data, whether security systems are installed. Dr. Kasser has very rightly pointed out in his early remarks about this security walls. Data storage security measures, that is the same. Then the name of the third parties, keep it on record with whom you are sharing. Data retention policy, that how much time is required to keep the data with you. And again here I would like to say that this law has extra territorial jurisdiction, which means that even if the data controller is outside UAE in other jurisdiction, but it is processing the data of data subjects, individuals who are in UAE, then this law applies to those data controller and processors who are not in the UAE. So what I mean to say is the companies, there are a lot of foreign companies working in UAE. So they should realize, for example, they have their subsidiaries here in the UAE, their branch offices here in UAE, and they send the data, personal data, to their head offices and their other offices in other jurisdictions. So they need to understand and know that when they send the personal data to other jurisdictions and the processing is done in somewhere else, this UAE law applies to such kind of processing as well. Thank you very much. This concludes my presentation, but I just want to make one more comment that, executive regulation is about to come very soon, maybe 1 month or 2 months, you never know. But once the executive regulation is issued, it will give only 6 months to data controller and processor to have the compliance framework in place, and 6 months is not much time. So what I would advise that the companies who are controller and processor, they should start, preparing processes and procedures and the compliance framework right now, because they won't be having too much time. We are receiving a lot of queries from UK and from US, from Hong Kong and Switzerland about the data privacy law of UAE, because they are afraid about the implication on their processing. So companies who are working with UAE, who are processing the data of UAE data subjects, they are already preparing for it, and they should prepare for it. And thank you very much. And if there is any query, any question, please do not hesitate to contact us. We will respond to you as soon as possible. Thank you once more.
Thank you very much, Seth. Can you hear me, Seth?
Yeah.
Yeah, you're clear.
Okay. Okay, there is a question from that. What are the biggest challenges for this data protections for for a company?
The biggest challenge, as I have explained, is to prepare and keep the regulatory framework, the compliance framework, I would say rather, the compliance framework intact, in place, in time. Actually, the challenge is 6 months period would be not good enough. For example, if we assume that the executive regulation is issued next month, then by the end of July, the companies will have to have the whole compliance framework in place, which is not an easy task. So this is the biggest challenge, that you have to prepare yourself to comply with the law within 6 months period of the issuance of the executive regulation. And the requirement, as I have explained you, is quite extensive. If you start from the mapping, it takes a lot of time, to see what kind of data you are collecting, where it goes, the whole life cycle of the personal data within your company. It's not easy to manage that data and comply with the law. So the biggest challenge is time. You have short time to comply with it.
Okay, what the date you're saying is for the laws to be implemented?
I'm not sure about the date, but what we are expecting is that executive regulation is due to come soon. Could be next month or maybe in the March, you never know, but it is already late. And I believe that the executive regulation will be issued soon, quite soon.
Okay. One more thing is that how you connect that there is I see that somebody have asked that what about this anti-dumping law? What's that connected with the data protection?
There is no connectivity. Actually, anti-dumping law is a different ball game, which is one of the trade remedy laws of the WTO. We are expert on anti-dumping law as well. We have been practicing for the last 20 years, and we have done so many cases in different countries, different jurisdictions. It has no relevance with the data privacy law. Anti-dumping law is quite different.
Okay, one more, the final question is that one, that how long it takes to do the assessment that for an individual or a company to know that what is the impact of this upcoming data protection law on them?
It depends actually upon the size of the company. If the company is huge and the personal data is in big quantity, it might take more than 6 months. But if the company is a medium-sized company, it might take 3 to 4 months. But I tell you, the minimum time would be 3 to 4 months. It will not be that easy.
I have question for all the experts. The UAE residents are suffering too much because of the data protection thing, because of the vendors. The vendors receive our data. I give an example, the real estate company, they receive the data. We purchase, our names are there. Same is the bank, same is the hospital, same is the airline, same is the insurance company. So what happened is that every day, every resident receiving so many calls, and from where they get the data. This is a challenge. This is menace for everyone. And this is because the vendor not protecting our data. That should be taken care by the government, that how they leak these data, and each residents are being bothered. I received 10 calls for nothing, and I have to say sorry to them. And it is coming from either for opening, teaching us how to trade, or buying property, or having such thing, insurances. So this is a menace. And I don't know how this can be controlled. With this event, I'm sure all the audience must have learned a lot about data. And I just want to say thank to everyone, a special thank to Sayyid Asif Zaman from Al Jabri Company Chartered Accountant, Ahmad Al Jabri Company Chartered Accountant, who has given this event and educated so many people who are looking, and they can go to YouTube and have that. And I really thank Sayyid Hassan Saab for his good comprehensive detail. I have understood a lot from you now, especially the consent part, that what right we have. I don't think so. Everyone know that they have a right to withdraw, because they only know they can give, but they are not aware that they can withdraw. And of course, Saifullah Saab, you have shared your experience, which is very important for all of us, especially for the compliances and periodical review. And I request all the organization to every 3 months periodical review their protection of data. And finally, Fahmi Saab from Malaysian, our business council. So thank you so much for your all good words for the council. And we are here to look onto it. So I will have, if you can have some word on these vendors, how we can tackle.
So yeah. I will rephrase what Dr. Kassim is saying, that every day we are facing and receiving a lot of calls from, it could be a credit card, it could be a property. So how, when this data protection law would be there, that somebody is selling our data, family must be receiving also calls, too many calls every day, that buy this property or have this credit card. So can you connect this with the data protection law, Mr. Saeed?
Yeah, I'll take on this question about Dr. Nisab and Asif Saab. Now you mentioned, Dr. Nis mentioned the vendors, and you also mentioned the word vendor, or the person who is making you calls or sending you the emails. So under the law, this person who is deciding or who is buying the data, as you said that someone is buying data from someone. So the person who decides to collect the data, to process the data, it is he, she, or it is a data controller under the law. So after the law comes in and the law is fully enforced, then if such a person who's buying data from, say, bank or the insurance company, then he's a data controller and he's under full obligation to make all the compliance of all the law, which I mentioned. And also, if he just called you in a fine morning without your consent, before using your consent, so he may be exposed, he, she, or it may be exposed to such heavy amounts of fine. Just for an example, Instagram in Ireland have a 405 million euros penalties in last October. And only for one reason, that they have processed the personal data of children. Children means the persons which do not have attained the age of 18 without their proper consent. So now these people who are calling you or who are selling our data unlawfully, they are the controllers. They will become controller under the law, and the law will be applicable on them, and they have to first take consent. But if they do not consent, Dr. Saab or the Asif Saab has a choice to go to the authority and ask that Mr. A, company A has misused my data. He is calling me. He is making my emails without my consent. So take appropriate action. And by the way, if you are not satisfied with the decision of the authority, then the case goes up to the level of courts. Then you have to take the matter to the court. So the strict penalties will be there. Of course, we need to have a culture and awareness and understanding among the data subject that we have these rights. If my right is infringed, my data is breached, so I have the right and how to access this right. That's why Mr. Saifullah has mentioned that it is very important that each organization know how to respond to a request from the data subject. When he said you are using my data unlawfully, don't use my data without my consent. So the company, the controller, the organization must have processes in place to stop them or to respond this request. So
but the vendor sells the data to XYZ, and they have the whole data and calling everyone.
So they both are responsible.
We do not know. We do not know how to find the guy who has called you.
Here, Mr. Saeed, the role will come, and their company, they will tell us where to file and who to catch and get, put them on heavy penalty and get some rewards.
How you can get it?
This, I think I will phrase that one. Dr. Kesar, till now, the data protection law is not enforceable in you. And as Mr. Saab has already told that it's in the process of that executive regulation is there. Once the executive regulations will be there, you will see so many cases of filing case against so many organizations. Fahmi, do you have anything to add on, please? Mr. Fahmi?
No, it's definitely a very interesting topic. As you know, we're all facing the same problem, but one thing for sure, these people, of course, they are trying to what do you call this, to make a living, right, by calling people and all this. But there must be some limitation and all these things. So this is what we will be looking at when the real law being enforced and how to go about it. And then perhaps next session.
The solution is in the first one, like USA, people have stopped receiving the phone calls. Any phone call, they don't pick up the phone. No.
I would like to add that I believe that once the executive regulation is issued and the law is enforced, you will not receive such calls. Either such calls, the quantum will reduce significantly. The quantum will reduce significantly because the real estate, the banks, the hospitals, they would realize now there is a huge obligation on their shoulders. So either there will be a reduced quantum of calls or maybe no calls. I'm sure with the enforcement of this new law, such a crank calls will be vanished ultimately in the next few years.
Thank you very much. And yes, Dr. Saab, we are running time. So, sure. And Mr. Afzal Hassani, are you there? You want to add on something, Mr. Afzal? I think he's busy. Anyhow, thank you very much for all the people who are listened to us, participated through Zoom, or they are from at YouTube watching this event. And some people, they have requested for the presentation, and I have already told that Mr. Saeed and Saab presentation will be sent to them. They will share the email addresses to us, and we'll send to them. And thank you very much. I thanks for the support of Pakistan Business Council Professional Council Abu Dhabi, and Mr. Femi from Malaysian Business Council is supporting this event and letting our business community members aware that this law, which is very important, is going to be implemented soon. So they have to get prepared on that one and to the individual. Thank you very much. Again, thanks all of you to attending this web. Thanks a lot.
Thank you. I appreciate for